Well, our speaker today is someone you probably all have known, but I'll share just a little bit of his bio and then turn the floor over to Mr. Tanick. For over 35 years, Marshall H. Tanick has represented clients in a wide variety of legal matters with emphasis on employment law, constitutional law, including defamation, privacy, and other communications, education law, animal law, pet law, land law, and business disputes. He was named to Minnesota's Lawyers Class of Attorneys of the Year for 2019. Welcome, Marshall. We're glad to have you.
Well, I'm glad to be here. Thank you very much for having me yet again. I can't quite see. Yeah, I was just looking for my Rotary cup of coffee here, and I couldn't find my Rotary cups. I have so many of them, but I can't. Isn't that the story? When you need something, you can't find it. So all I was able to find this morning to get ready for this is to put on my bow tie, which I rarely wear too. So it's a little bit something new. At any rate, happy to be here talking about a case and some issues that everybody is pretty familiar with and have their own. Many people have their own opinions, some differing from those that I might express. When I was originally approached to make this presentation, I had a lot to say, and I still do, but it seemed like just about everything has been said. But I've been a little bit on the circuit talking about this case in different forums and venues for some period of time. Some of you may have heard some of the earlier presentations I've given them on this topic. And I probably have one more in me, I guess. Once the trial is over, maybe you'll invite me back to kind of assess what happened and kind of figure out how it happened and what happens next. In the meantime, I've been contacted. I've been engaged by an international media organization to be one of its trial commentators. I'm not sure how that's exactly going to work, but I'm sort of on call to be a commentator during the course of the case by no less an organization than the BBC. So if any of you get the BBC there on your shortwave ham radios or whatever, you might hear me talking a little bit about the case. I guess the last juror was seated just this morning, so it looks like the trial is going to go forward and going forward next Monday with the 16 jurors, 12 jurors, and 4 alternates. And that's the Chauvin case. As you know, as we all know, the Chauvin case is being tried first and separate from the case against the other 3 officers. So let's go to the next slide. Michelle's going to operate our slides, I think, hopefully. Michelle, can you get the next slide up there?
I am sure trying. I'm pressing the next button, which is the tried and true.
There we go.
All right.
We all kind of know the background facts, so we'll skip that because we all know what happened on Memorial Day and we know how we got here. It's not that unusual for a major case like this to take 10, 11 months to get to trial. Many felony cases, especially homicide cases, murder cases, take at least that long to get to trial or sometimes longer. So while it seems like it's been an eternity because there's so much that's been said and written about this case, actually it's on a pretty short time frame, especially considering COVID and the fact that the courts have effectively been closed for a long period of time. While we're talking about the criminal case, of course, that's the main focus. There has been, and still technically is, as we now know, a civil lawsuit. The city and the 4 officers were sued in a wrongful death claim by the Floyd family, and that was really below radar until last week. And then the city announced, and the Floyd family announced, that it settled that case for $27 million. All kinds of questions about not only the amount, but the timing of that, because as we know, it was announced while the jury was still being selected. I'm not aware of any case in which any similar case, and there's been settlements, of course, in most of these cases. The Noor Justine Damon case was settled for $20 million. The Castile case with Yanez, the police officer in the Castile shooting, who was acquitted, by the way, a few years ago in St. Paul, that was settled. I forgot the amount. It was something like $8 or $9 million. And around the country, these cases do get settled, but they rarely get settled before the criminal proceedings are over. The Noor case, the settlement was announced a couple of days after Noor was convicted. In the Castile case, Philander Castile, the settlement was announced a couple of days after he was acquitted. So while the settlement is oftentimes agreed to, It's just hardly ever, if ever, announced during the trial, and certainly never while jury is being selected. There's all kinds of questions that have arisen regarding why the announcement was made now and what effect it might have on the jury. And I think for a moment or two, a lot of people thought that it might result in a continuance of the case, a postponement of the case for some period of time. And the defense even sought to have revisit the case of the issue of change of venue, but the judge denied both of those. I suspect that if there is a conviction here, that is going to be a significant issue on appeal. Whether it works on appeal or not, I don't know, because it's difficult to establish prejudice without jurors actually saying they were prejudiced by hearing about that settlement or knowing about it. So we'll just have to see how that plays out. There's also some administrative matters that are still lurking in the background relating to whether the city is going to compensate the police officers for the legal fees they've incurred in the civil case. And there's still technically some issues about the future employment of the officers, whether they're going to be able to challenge their terminations if they're acquitted. So there's still some other issues pending out there, but most of the focus, of course, is on the criminal case and the Chauvin case in particular. So we'll go to the next slide. Next slide, please. All right, well, we know when the case is going on and where, and it's live streamed. Most people had an opportunity to see some of the jury selection. It's kind of soporific, I think. Expect a little bit more fireworks, but that's what we're going to see during the course of the trial. It is, as we know, unique in Minnesota history to have a televised trial. We know it happens in a lot of other states, California, the O.J. Simpson case, Florida, Court TV, most other states do have some or all of their criminal cases subject to television. Most of them aren't interesting enough to attract a television audience, but in Minnesota, we have very restrictive rules on what are called cameras in the courtroom. Those rules apply not just to television, but to still photos, audio recordings, video recordings, any kind of broadcasting of any type. In Minnesota, the rules essentially prohibit what we're seeing now. In Minnesota, unlike almost every state in the country, and kind of contrary to Minnesota's transparency and openness as part of the Minnesota government and judicial system to some extent, in Minnesota, a criminal case cannot be televised or photographs or any kind of reproductions broadcast without the agreement of the judge, and most judges don't want that, and without the agreement of the defendant. And there's not many defendants in criminal cases who want to be on television. In this case, it was the defense who initially pushed for having the case on television. The prosecution resisted that because they felt that it might intimidate or scare away witnesses, jurors and witnesses. So the prosecution was adamantly against it. And the judge early in the case ruled against televising the trial. Because of the tremendous amount of interest in the trial and the difficulty of being able to seat people in the trial, and then with COVID, the social distancing, the judge concluded largely as a matter of administrative convenience that because people can't come and see the trial, in addition to security, the only way the public is going to be able to know what's going on in the trial, other than reading reports about, is to actually see it live. So that's how the live streaming came about. And it may be a forerunner for other cases in the future, high-profile cases. But as I said, this is actually in contravention of the current rules that exist. It's an exception to the current rules, and we may never see it again. Or, depending upon how it goes, we may see it again. This may be at least a foot in the door. I doubt that we're going to see fully, 24/7 coverage of trials, but it may be that if this works out okay, acoustically and video-wise and efficiency, it could be that in the future that the courts will allow some cameras in courtrooms for portions of cases, important criminal cases, or highly significant civil cases for that matter as well. What we're going to see is what you've seen already. The camera is going to be focused just on the judge, the lawyers, the parties, Chauvin, and the witness. We're not going to see the jurors. Occasionally there's a slip up here and there, but it's not supposed to. But it's a pretty tightly controlled setting we're seeing, and it's just focused solely on the witness, the judge, the lawyers, and the defendant. There is going to be, of course, as we know, another trial potentially of the other officers. We'll talk about that a little bit later. But they were separated from the Chauvin case. Initially, they were all going to be tried together, and the judge, the defendants moved for separate trials. All the defendants wanted separate trials, especially the other three officers, and the judge granted that, so they'll have a separate trial, which is viewed by many observers as being quite advantageous to the other three defendants. They'll obviously, they don't have to be in the same courtroom as Chauvin. They don't get tarnished with anything against him. They're not going to have to defend themselves as to what Chauvin did, at least in this case. But more significantly, they can sit back and see how the prosecution presents its case. They can hear every witness testify, and then they can use that, obviously, to prepare for their own case and cross-examine the witnesses based on what they've said in this case. So it's a tremendous advantage. It's kind of like being in the NCAA basketball tournament and getting a bye all the way into the Final Four. You don't have to play 2 or 3 games until you get to the Final Four. That's kind of what it is for the other officers. They don't have to go through the rigors of a trial right now, and they certainly can benefit from learning how the case plays out. They'll be able to identify what works with this jury and what might not work with the jury. It's just like a trial run, no pun intended. So it's a tremendous advantage for those defendants. And also, they're going to be tried separately. Chauvin's not going to be part of that case. So it's a real significant advantage to them to have this trial separate. Jury selection's already done. I prepared this outline in anticipation of talking about jury. I don't have much more to say about the jury selection other than it was a little bit unusual in certain respects. There's more minority members of the jury than was expected, people of color. I think it was 6 or 7 people who identify as people of color or minorities, which is a little bit higher than was anticipated. Generally, in Hennepin County cases, criminal cases even, it's very rare to have more than 2 or 3 people of color in a jury. And in civil cases, which is primarily what I do, I don't recall, I can recall 1 or 2. I've never had a jury with more than 2 people of color on it. And other lawyers say the same thing. So it's there's a high degree of people of color in this jury compared to the population generally in Hennepin County. And that seemingly would bode well for the prosecution. But the jury's a mixture of different people, and we all come from different walks of life, and it's not unusual that we get what we got with the jury. Some people are leaning, and I won't say leaning, but some people are coming at it from one direction or another. There's a few professional people, there's retired people, there's some younger people. It's just a melange, and that's what a jury of one's peers are. Venue is still up for grabs, even in this trial. I mean, it's possible, unlikely because the venue thing has been beaten around so much, but it's possible that if something really explosive happens, the judge could still try to change venue, but I think he pretty much shot that down largely for the reasons of efficiency and economy. The notion of picking up this case and starting over again in some other part of the state is pretty unusual. Although if something really unusual or explosive happens, it's possible. But that still begs the question of venue for the other officers in their trial. They may make some effort, depending upon what happens in this case. Their trial is coming up, as you know, in late August. They may make an effort to try to get venue changed for their trial, and it might be easier for them to do so, depending upon the publicity. Well, we know there's going to be a lot of publicity, but depending upon how this case plays out, it may be that the other officers will want to have a change of venue and be in a different part of the state. And the judge might at that point be less disinclined, there's a double negative, more inclined to think about changing venue because there might not be as much news coverage and media coverage of the second case as there is in the first case. That case is scheduled for the summer. It's a little bit easier to move things around the summer than the winter. So it's not a certainty that the other trial is going to take place here in Hennepin County. So venue is still an open issue for the second case. Let's go to the next slide. The legal issues, there's going to be 3 principal legal issues presented during the Chauvin case. The main issue, it looks like, and from questioning the jury and other reports we've been reading, it looks like the main issue is going to be cause of death and the toxology issues. The defense is going to lean extremely heavily, and that's probably an understatement, on the argument that Floyd would have died anyway, or he died because of his heart condition and because of his use of drugs, and the judge is allowing some evidence of his drug use to come in. Not a lot of it, but that's going to be at the center of the defendant's case. And as we all know, the initial autopsy done by Hennepin County said that the cause of death was Floyd's heart and the drugs he ingested, and did not say the cause of death was the knee on the neck. Now, I suspect the knee on the neck didn't help much, but nevertheless, the prosecution has to prove that his death was caused by Chauvin's knee on his neck. And that's going to be a fierce battle. It's going to turn on expert testimony from both sides. I think the defense has some celebrity autopsy expert, celebrity coroner type, who's going to come in and talk about why the death was contributed to other factors. In civil law, there is something known as the thin-skulled plaintiff, or it's sometimes called eggshell plaintiff. Who is the recovering lawyer amongst us there? Who is the recovering lawyer amongst us?
Jillian.
Pardon?
Jillian.
Yeah, Jillian, you remember that from first year law school, right? The thin skull plaintiff or eggshell plaintiff. What is that, Jillian? This is like being back in law school, isn't it?
Goodness, I did not expect to be asked questions here, just like I didn't prep for law school. That was 25 years ago, Mr. Tanick.
All right, well, I'll remind you. You'll remember when I tell you. I didn't mean to put you on the spot there. I know Jillian never wants to be put on the spot. Being a member of the city council, she never gets questions thrown at her.
Well, I didn't take criminal law, and I was a trademark and copyright attorney, so I didn't really dig deep into
this. Okay. That's okay. It's a civil law concept. The notion is that certain people have different dispositions, and if you cause an injury to someone in civil law, but they're predisposed to that type of injury, you're responsible for it nevertheless. That's called the eggshell plaintiff. For instance, if there's a car, let's take a typical car accident. If you hit someone who's a typical car accident, but that person has some greater vulnerability, or they have some greater disease that causes them to be more injured than a normal person, too bad. You take the person that you've injured the way it is. You can't base it on a normal person. You have to take it on the way it is. And that's sort of a concept in civil law. In criminal law, it may have a bearing in this case, because the argument that Chauvin's people will make, that the defense will make, is, well, he didn't cause the deaths. Floyd was predisposed to be more likely to die because of his condition. And the prosecution will come back and say, well, that's, he can't defend himself on that. This was, the person he assailed here was more predisposed to maybe that kind of treatment than someone else who was in better condition, but that's not a defense at all. If he died because of what Chauvin did, it doesn't matter what his pre-existing condition was. The prosecution will also say that, well, maybe there was a number of contributing causes to Mr. Floyd's death: his heart condition, his drugs, his excitation condition. But nevertheless, Chauvin's knee on his neck certainly didn't help, and it was a substantial contributing cause. That's another law school concept. Even if Chauvin wasn't the sole cause of the death, if his actions substantially or greatly contributed to the death, he still could be held liable. Another issue is mental state or mens rea. That's another law school concept. And what was Chauvin's state of mind? And we'll get to that when we talk about the different charges against him. Did he actually intend to kill Floyd? Well, he's not been accused of actually intending to kill him in a premeditated way. He didn't come to the scene there intending to kill Floyd. The question is whether his behavior was so abominable and so reckless that death was likely to occur. And that gets into the different charges, which we'll talk about in a minute. So those are some major issues. Another an issue that seemed to be more significant at the beginning of the case, but it's now kind of receded into a second or third position, is the claim that Chauvin was acting properly. The police training manual that existed at the time did provide for using neck restraints. Now, we know that that's been changed by laws, federal laws in the past, but federal laws, state laws, and the Minneapolis Police Department itself has changed its regulations and rules. But Chauvin's the training manual that Chauvin had said that neck restraints are permissible. In fact, Chauvin was a trainer who used that manual. So that'll be an argument that Chauvin people will make. Now, the prosecution will say, well, the fact that it was permissible at the time doesn't necessarily mean you can overdo it. You used it excessively. It's permissible for officers to carry handguns, of course. That doesn't mean you should go shooting them, shooting people if there's no reasonable cause to do so. So the fact that it was permissible to use a neck restraint doesn't necessarily justify an 8.5-minute neck restraint in these circumstances. Another issue that's going to come up is whether Chauvin is going to testify or not. That's something that the defendant does not have to announce it during the trial. Generally, if a defendant testifies, they testify at the end of their case. They're usually the last witness to sort of clean everything up, and they usually don't make that decision until the very end. The defense could come to the conclusion, of course, with Chauvin's consent, that we don't think the state has proved its case. We're willing to, take the risk that you don't testify, Mr. Chauvin, and we'll hope the jury will acquit you without you testifying. Now, Chauvin obviously has to make the decision himself, but I say most defendants, not all, but most, will take the advice of their counsel. We saw O.J. Simpson; he didn't testify. Noor did testify. Noor testified in his case, and it would seem that Chauvin probably has to testify because the video is so graphic and it's there and everyone has seen it, and they'll probably show that video about 20 times during the trial. It'll be like a Zapruder film. They'll keep looking at it in slow motion and backward and forward. And Chauvin probably is going to feel, and his defense team is probably going to feel, that he has to testify to explain what he was thinking at the time, why he did it. Because we know what he did, and we know what the consequences was, so it seems incumbent on him to have to testify. But that opens up a lot of cross-examination. They can go through that video frame by frame and say, what were you thinking at this point? And did you realize you were on his neck for 4 minutes at this point? And how about 5 minutes and 6 minutes? And did you hear him say, I can't breathe? And did you hear him say these things? And the cross-examination can be quite brutal if he testifies. So it'll be a tough choice, I think. It always is a tough choice. The statistics show that about 90% about 95% of all defendants who don't testify get convicted. So that's pretty high percentage. On the other hand, the statistics show that 90% of all defendants who do testify get convicted. So, but all those statistics tell you it's about 90% of people get convicted when they go through a trial. That's why there's so many plea bargains. But it can be a very daunting challenge for him to testify here. Questions have arisen about, so that's another issue that'll come up: the toxicology issue, the autopsy issue, the training issue. Another issue that's going to obviously be emphasized by the defense is the old reasonable doubt issue. The defense is really going to hammer that this is a criminal case and we have to be convinced beyond a reasonable doubt. And just because you think he might be guilty, that's not enough. Even if you think he's probably guilty, that's not enough. You have to come to a decision based upon a moral certainty, and you have to be more than convinced. You have to be almost certain, at least reasonably certain, and that's a high standard. And to the extent that it provides some leeway for jurors to say, well, I think he did something very bad here, and I think he's culpable, but I don't think the state has proven his case. It's possible that the jury could determine, or at least some jurors could determine, that that the state hasn't proven his case beyond a reasonable doubt, which is the criminal standard, as compared to a civil standard, which is just a preponderance of evidence, more likely than not. Civil standard is 51%, kind of 49%. Criminal standard is sort of 99%. And they have to convince all 12 jurors. If they can't convince all 12 either 12 jurors all can vote to acquit, or they can vote to convict. But if there's not a unanimous jury, there's a hung jury or a mistrial. Mistrials are extremely rare in Minnesota. I think I gave a presentation, somebody may have been a different presentation I gave, where I said there's only been 4 mistrials that I'm aware of in Minnesota history, recent history. Probably is more than that. I can't track all of them, but they're very rare. However, earlier last month in February, there was a mistrial in a road rage case in St. Paul. There was a car accident and it led to a road rage, and one of the drivers shot the other driver, was charged with murder, and it was tried in St. Paul, and it was a hung jury, pretty rare hung jury, and the prosecution had just decided yesterday to retry that case. Often when there's a hung jury, the prosecution says, well, it's too much time, too much effort. If we can't convince these 12, we're not going to try again. That's usually what happens in hung juries, but not in this case. I mean, if there is a mistrial, a hung jury, I suspect that the prosecution will just have to do it again, because the pressure, political pressure, and other pressures, interest of justice, would probably demand a second trial here. But that's a bridge we haven't crossed yet, and we'll see how that turns out. Let's go to the next slide for a minute. Can we go forward a little bit more and see if we have the charges here? Oops, don't we have the charges there? Guess not. Okay. Okay. So let's talk about the charges here. Let's go back. I thought I had included the charges here, but I guess I hadn't in this. They didn't come up. But there are, excuse me for a minute here. There are, as you know, there was a lot of jockeying back and forth about what charges could be brought and what couldn't be brought. Chauvin has 3 charges against him. The most serious charge is second-degree murder. First-degree murder is premeditated murder. That's planning ahead of time, malice aforethought. That's the kind of stuff we see in television and movies, and it's the most serious offense. In some states, it's a capital offense. In Minnesota, it's automatic life imprisonment. That's first-degree murder. He's not charged with first-degree murder. He's charged with second-degree murder, which is called felony murder. That consists of there was no intent to kill. In order to prove second-degree murder, you have to prove there was no intent to kill, but he did intend to do the action he did, and it caused someone's death under circumstances that would reasonably lead to someone's death, even if he didn't intend to kill him. And that's up to a 40-year sentence. Another charge is the third-degree murder charge. That's the one that was bandied about up and down. They went up to the Supreme Court on that. That was the Noor case. In the Noor case, Noor was convicted of third-degree murder. Third-degree murder is what's called a depraved mind. It means that your action was so reckless that someone was likely to get killed, even if you didn't intend to kill the person. In Noor's case, he shot, in the dark out the window. He didn't know what he was shooting at, supposedly. And the argument was, we didn't intend to kill anyone. He didn't even know if anyone was there. He just was reckless, extremely reckless. He had a depraved mind. And there was a high degree of risk there that he would kill someone, and he did. That's third-degree murder. It carries a 15-year sentence. The Noor appealed his case on the basis that under the old law in Minnesota, old cases in Minnesota, that third-degree murder charge is generally restricted to cases where someone does something that's a great risk to the general public, like driving a car into a crowd or spraying a rifle into a crowd without a specific target in mind. But the Minnesota Court of Appeal said, no, our third-degree murder can be applied to a single shot at a single person, as in the Noor case. So initially they had charged third-degree murder in this case. The Judge Cahill threw it out, but as a result of the Noor case, he brought it back into the case. So third-degree murder is in the case. And it's considered to be very helpful to the prosecution because the more charges you have, the more likely you are to get a conviction. But also it gives the jury a possible out. If the jury can't agree on second-degree murder, they could fall back and say, well, it wasn't that bad, but third-degree murder might give the jury sort of a compromised position to arrive at. So that's why the defense, Chauvin, fought so hard against keeping that in the case. And it's possible that if there's a conviction on third-degree murder, that could be appealed in reverse because the Supreme Court has decided to take the Noor case. The Supreme Court is not going to decide the Noor case until sometime this summer or fall. But if the Supreme Court says that third-degree murder doesn't apply unless your action threatens a number of people, not just one person. In other words, if Chauvin had run into the crowd there in 38th in Chicago and started shooting his firearm, that might be third-degree murder. But because he only had one victim here, if the court in Noor, in the Supreme Court says in Noor that they say that third-degree murder doesn't apply, if Chauvin's convicted of third-degree murder, he might be, ultimately that charge may have to be dropped. So there's still, the outcome of the case here may depend upon what the Supreme Court rules in the Noor case. Then there's a third charge against him, and that's second-degree manslaughter, and that's an unintentional killing that essentially is criminal negligence. And that's the easiest to convict someone on because they don't have to show this high degree of depraved mind. They don't have to show that he committed some kind of felony. It's essentially a version of criminal negligence. And it's a much lesser penalty. It's a 10-year, up to 10-year sentence. And that's the lowest possible charge against him. The 3 other officers are all charged with aiding and abetting those 3 offenses. So you could have a conviction on one of the counts, 2 of the counts, all the counts, none of the counts. So we'll just have to see how it plays out. And the jury there could be a mistrial as to some counts, but not all counts. From the prosecution standpoint, they need only to convict him of one count, although certainly they would much prefer the high-level second or third-degree felony compared to the manslaughter charge. And I think if Chauvin were to be convicted of the manslaughter charge, it would be probably considered a, quote, victory, unquote, for the defense in that case. Even though there's a conviction, it's a much less serious offense. Let's go to the next slide. And how am I doing? Got a few more minutes to wrap up here. Next slide, please.
I'm trying. Sometimes it doesn't like
That's
it should.
okay. You're doing better job. Doing a better job than I am.
It doesn't. So let's see. Go ahead and keep talking. I'll
Okay,
the slide up in a
let's
second.
see what else we'll talk about here. It's anticipated that the trial is going to take, what, 3-4 weeks? And it probably will. It was anticipated the jury selection would take about 3 weeks, and almost did. So I think we're going to have a long trial, and the jury is probably going to be sequestered during its deliberations. The jury, as you know, is not sequestered. The jury has been instructed by the judge not to watch television, not to read newspapers, not to talk to anyone, not to do anything, not to breathe, not to eat, not to live, just to pretend you don't exist anymore. But no, seriously, I mean, we've seen already some of the jurors said, yeah, I've seen a little bit on TV, or one fellow said, I saw something in my workplace, they had the TV on. But the jurors will try to follow the judge's instructions. Whether they can really be insulated or not, I don't know, but usually they manage to at least say they were insulated. And if something, again, explosive or unusual happens, it may be that the judge will sequester the jury during the balance of the trial. But that's pretty difficult to do. We have very few sequestered juries in Minnesota. I think I can only remember one time when a jury was sequestered. The O.J. Simpson jury was sequestered, but generally the judge lets them go home and tells them to, not talk to anyone about the case and not hear about the case and not watch TV or newspapers or internet.
Marshall?
Yeah.
Are they looking for people who know nothing about the case, or just
everybody knows about the case. I was going to talk about that, but since the jury's been selected, I guess we kind of know what happened here. No, I mean, ideally, in most cases, most people don't know anything about the case. In this case, just about everybody said, yeah, I've heard about it. Some have seen the video. Some have talked about it. Just about everybody knows about the case, and that doesn't preclude someone from being a juror. The question is whether they can be a fair and impartial juror. Now, some jurors have said, well, I know about the case, I've seen the video, and I've kind of made an impression on me, and I have an opinion. Some of the jurors who said they have an opinion still are on that jury because they said, well, I'm open-minded and I'm willing to listen to both sides of the evidence, and the judge allowed them to be on the jury. I think in an ordinary case, they would have been removed from the jury, but I think the feeling was that if we remove everybody who's heard about the case or has a feeling about it or has some opinion, we'll never get a jury. So to some extent, they have to compromise a bit and try to pick jurors that at least say they're open-minded and not biased and can make a decision based on the facts and evidence. And that's what the jurors all said, that, yeah, they'll listen to the evidence and they'll make a decision based on the evidence. But we all know that people bring to their view of evidence and decision-making their own biases, their own prejudices, their own ideologies. So it's very hard to find people who are totally unbiased, neutral rather, and unaffected by this. But they've got a jury now, and we'll see what happens. And that could be an issue for appeal. But I think that the judge and the lawyers did a pretty good job in picking a jury that at least will withstand an appeal. Ordinarily, incident juries get picked in half a day. So the fact they went through the 2.5 weeks to pick a jury, I think, is going to make it very difficult to appeal the case based on a bias on the part of the jury. They've got a real mixture there. Of people. Yes, question. Yes.
To what degree does the defense have to object to a juror? Can they?
Well, they did. Yeah, the jury, the defense had 15 what are called peremptory challenges. That means that, and I think the judge even extended that, but the judge gave them about 12.5 people that they could automatically remove. I don't want this person on the jury. I don't like this person. Not personally, but I just don't want this person. It's peremptory. It can be for any reason at all. Okay, just like picking a food off a menu. You can pick what you want, whether you just pick what you want, and you can say I don't want this, and you get rid of it. The state had 9 peremptory challenges, so 27, and I think both sides used just about all theirs. So there were 27, about 24 people who would have been the jury that were if you will, kicked off the jury by the lawyers, just saying, I don't want this person, I don't want this person. There were other jurors who were removed for cause. Either the lawyer said this person is reflecting a bias or a prejudice, or the judge thought that they were too biased or prejudiced, or there are other reasons they couldn't sustain a 3-week trial, or they have family obligations, or they have an illness that prevents them from being in court every day. So a lot of those people got removed for trial too. So what you have is the last survivors are the ones who are on the jury, and you have a mix of people on the jury, but they all have managed to survive being removed from the jury. A lot of people were removed from the jury, but these are the ones who weren't removed. They will be sequestered during deliberations. We don't know how long the deliberations will be. In the OJ case, it was what, 1 day? In the Noor case, it was about a day. Maybe it was 2 days in Noor. I don't know. But there could be lengthy deliberations. There have been some classic cases where the jury deliberated for days and days and days. And I suspect that will be the case here. I don't think the jury is going to come back within hours with a decision either way. So we can expect that the jury will be deliberating for a long period of time. We talked about sequestration. Sequestration is difficult because you have to have, with 12 jurors, you have to have marshals there with them at all times. You have to put them in a hotel. It's uncomfortable for them. It's costly for the county to put people up, but given how much money the county has spent on fencing alone, it probably won't amount to much. But sequestration is extremely rare, but it will occur. The judge has said he's going to have the jury sequestered, in other words, put up in a hotel and kept away from any people during their deliberations. There's all kinds of possible appeals here. As I said, it's a little bit premature to kind of figure out what's going to be appealed, but if Chauvin is acquitted, the state can't appeal, as we all know, under the double jeopardy clause of the Constitution. If a person's acquitted, they can't be tried again. They're done. If he's convicted of any charges, he can appeal. Or if there's a hung jury, they can appeal too. But if Chauvin's convicted of any of the charges, he can appeal. As I pointed out, some of those charges might be vulnerable to appeal. The third-degree murder is still an open issue as to whether it does apply here or not. And the Supreme Court's going to decide the Noor case in several months to decide whether a third-degree murder charge can be brought against someone who isn't reckless as to a group of people, but just as to one person. The second-degree murder charge could be appealed, and of course, other charges could be appealed. If there's an appeal, the appeal process in Minnesota generally consists of going through the Court of Appeals, and that's about a 9-month process. And then either side can appeal to the Minnesota Supreme Court, which has discretion on which cases to hear or not. The Minnesota Supreme Court hears about 15% of all appeals. In a case like this, it probably would hear it because it's so high profile. But that process takes about a year or two. Well, not a year, not at least 9 months and up to a year. So and then there's post-trial hearings and motions. If there's a conviction here, we may not see the end of this litigation until sometime in 2023, if it goes through the appellate process, probably at least a year and a half, 2-year process. Meanwhile, we still have the other case hanging out there. We don't know what's going to happen to that. What might happen to the other case if if Chauvin is acquitted? Some people have said, well, if Chauvin's acquitted, they're not going to try the other officers. Because how can they try the other officers? They're only charged with aiding and abetting. If Chauvin's acquitted, how can they try the other officers for aiding and abetting someone who wasn't guilty? They can. It happens occasionally. There's conspiracy cases where one person is acquitted and they try the second person for conspiring with someone who's innocent. Not innocent, but acquitted at least, not guilty. So I imagine that there'll be enough political pressure and other reasons that the prosecution, even if Chauvin's acquitted, I don't think they're going to say, well, that's it. I guess it's time to go to the locker room and wrap it up. I think the public will probably demand, say, okay, well, that was one jury in one case, and now you have the other case. And apart from public pressure, there's also just other interests involved here. So I don't think it's a given that if Chauvin's acquitted, the other officers will walk. I think what is possible is if Chauvin is acquitted, there may be some plea negotiations and some plea bargains to plead guilty to some lesser charges, possibly. Now, if Chauvin's convicted, that's going to put a lot of pressure on the other defendants to probably plead guilty to some lesser offenses too. So it's possible that second trial may never happen, depending upon the outcome in the first trial. So
will the other 3 officers be tried together?
Yes, the other 3 are all going to be tried together, unless that's changed too. But the other 3 are sort of lumped together there. Now, Chauvin, if Chauvin testifies in his case, they can call him as a witness in the officer's case. The other officers would like to have Chauvin testify and point the finger at him. And if Chauvin's convicted, the other officers can point to that and say, look, Chauvin made us do it. We were rookies. We were doing it in his direction. He was the lead officer there. So one of the big defenses for the other officers will be, he made me do it. Don't blame me, blame him. And if Chauvin is probably going to be a central player in case number 2. However, if he doesn't testify in the case, and even if he's convicted, he can still take the Fifth Amendment and not be involved in the second case. So the second case hasn't taken shape yet. Yes, Michelle.
I've got a couple of questions here in chat that folks would like to have answered.
Sure, go ahead, fire away.
The first one, what do you think of the Attorney General's office prosecuting instead of the Hennepin County Attorney?
Well, there were some real bumbles and stumbles by the Hennepin County Attorney's Office early on in the case. When I'm saying early on, I mean the first few days after Memorial Day. And there was a lot of public pressure against Mr. Freeman, the Hennepin County Attorney. There was some release of information that wasn't handled very well. There were some concerns that the Hennepin County Attorney wasn't keeping a lid on what was being said by public officials. And so they brought in, Keith Ellison stepped in as the Attorney General, and it's fairly unusual, although the Attorney General's office oftentimes will aid local cases, local prosecutors in complex cases because they have more people and more expertise. So it's not unusual to have someone from the Attorney General's office participating in a case with the county attorney. It's extremely unusual for the Attorney General to take over the case in its entirety. And of course, they've got, I think I've seen that there's 14 or 15 different people in the Attorney General's office working on facets of the case. They're not all in the courtroom at the same time. They couldn't be with social distancing. And they've hired some experts. Neil Catian, I don't know if you know who he is, but he's with the Justice Department. He's kind of a big celebrity lawyer from Washington, D.C. He's part of the defense team. They've got about 15 different lawyers in the Attorney General's office working on various facets of the case. Meanwhile, you got one lawyer defending Chauvin. He's got a couple people on his team, but he's certainly outmanned just numerically. The state's throwing a lot of resources at this case, obviously. And the political outcome, there's going to be some political repercussions either way. If the case doesn't turn out well for the prosecution, I suspect there's going to be some political repercussions across the board at different levels.
We might need to have you back and give us the lay of the land then.
One other thought talking about the lay of the land is instead, another thing that's kind of interesting to think about talking about the jurors is, the jurors were asked all kinds of questions about their bias and whether they've seen the video, and whether they, do they support Black Lives Matter? Do they have family members who are police officers? All that kind of stuff about the jurors personally. But what they weren't asked at all, I don't think, I didn't sit in at all the jury questioning, but I think there's a 2,000-pound elephant in the room here, and that is, what do the jurors think might happen? Are the jurors concerned about what might happen if there's an acquittal? And we all know, is Lake Street or downtown going to burn again? Now, there were some euphemisms used during jury selection to address that. Some of the questions asked to the jurors by the lawyers, and they did a good job, and some of the remarks by the jury was whether they're concerned about their own safety or their family's safety.
Do you think that the civil suit might have been done at this point in time to preempt any violence that could be occurring in the streets?
Maybe. It might have been. It might have been. Of course, they could have announced it later, but that's a possibility. That's a good point, Michelle. It could be. But
I'm going to have to stop you here, Marshall. We are out of time, I'm afraid.
Okay, I'll just make my last comment here. Those comments about safety of the jurors, I think, is a euphemism for whether they're concerned about what an acquittal might mean here for what happens in the city here and whether that's going to be a factor. And we don't know, and I guess we'll find out. So thank you very much for having me here. If there's a couple of chat questions, I've got a couple minutes to talk about, answer some questions. I appreciate being here, and maybe you'll be kind enough to invite me back to talk about after the trial, a postscript as to what happened. Thank you very much. Watch for me at BBC for all of you BBC fans. I don't know. I don't watch the BBC.
Thank you very much. Nice to see everybody. And we are going to close the club session, as we always do, reciting the four-way test of the things that we think, say, or do. First, is it the truth? Second, is it fair to all concerned? Third, will it build goodwill and better friendships? Fourth, will it be beneficial to all concerned? Thank you, everybody, for joining us. I'll stay on, and Marshall, if you can stay on, anybody has further questions, happy to do that.
Yeah, I'll stay around for a few minutes. I see there's a number of questions. Chat, I don't know if they're questions or comments or criticism, but thank you. I appreciate the opportunity to talk about this case. Let's see, chat number one. Okay, a lot of chats. Okay. Mary Timmons, I don't know if you. Oh,
We got the two in.
Okay, I know very little about the civil citizen, Brian, but do people think the decision was made to oh, that was a question asked. Okay, that was fantastic. Thank you very much. Thank you, thank you, thank you. Jillian, thank you. I'm sorry, Jillian, I didn't mean to pick on you. Okay, just whenever there's a lawyer in the crowd, I like to see something. I like to.
You identify as a lawyer, you open yourself up.
Yeah, well, I taught a little bit in law schools, and that's what cruel law professors do. That they pick on someone in the class and make them feel inadequate.
What are your thoughts about the safety of the jurors? That was one of my, and I had a friend who was like on the list for jury duty, and we'd been like watching and hoping, but what do you think?
Well,
like,
you know, I mean, there's been very few instances of jurors in these big profile cases around the country being threatened or anything. First of all, the courts are very, very careful to try to keep their identities secret. It doesn't always work. And they're still battling. I think in the Noor case, did the court allow the jurors were anonymous? And I know that the media always wants to know who was on the jury because they want to interview them. And I understand that's their job. So there's a real tug of war between media and courts about that. And I think they're still battling that out over the Noor matter. Interestingly, in the newspaper the other day, Star Tribune, they had a good article about some interviews that the reporters did with jurors in the Freddie Gray case. That was the Baltimore case. And they were asking the jurors some of those questions about safety. So jurors' names get known in some of these high-profile cases, but there's very little indication that jurors have ever been threatened. Although with the internet these days, who knows? But there's been very little likelihood of, you know, jurors being the subject of violence or threats. But who knows? I mean, this is a unique case.
Anonymity should be.
But anonymity should help. But the other thing, as I said, I think the bigger concern about safety isn't so much the juror's safety, it's the safety of the community as to what might happen either way, depending upon the outcome of the case. But there's going to be a lot of armed patrols in the streets of Minneapolis when that jury verdict is announced.
How long do you think the whole trial might take?
It'll take
months, weeks?
3 or 4 weeks. It'll be over by, be over by late April, early May.
Oh, back to May.
Yeah, probably. Yep. All right. Any other questions? Do you have my sheet there still? Do you still have my PowerPoint there? I don't know if I have the last piece of the PowerPoint. It's kind of fun.
Yep, I've got it, but it's down.
All right. So because the last page of my PowerPoint, what didn't get in there is I had the verdict form and I put on there, how do you vote? Guilty, not guilty, or I don't know. So, and yep. I've kind of taken some polls at some of the places I've talked about this, and I think it's. Oh, let me make. Yeah, this is a good point. I should have mentioned this before. There was a survey, a Gallup poll type survey, a good one. I mean, for whatever the polls are worth after the last election, I don't know, but there was a poll taken by a reputable organization right early on after this incident. And it was a national poll, so it encompassed people from Alaska to Florida and Hawaii to Maine. But 55% of people in this SNAP poll thought Chauvin was guilty. That doesn't tell us much, but this is right in the wake of, everybody saw the video. That same poll was taken again 2 weeks ago. National poll, so this isn't a verdict, this isn't a jury here in Minnesota, it's a national poll. And the poll reflected 29% thought Chauvin was guilty. Now, we don't decide criminal cases based on polls, but it's really remarkable to see that gap. What I think it suggests is, in the immediate aftermath of what happened, and everybody saw that video, and it was, heinous and unspeakable and just beyond the pale. And people, immediately thought, well, this is terrible and he's guilty. But, people are becoming aware of some of these other issues about Floyd's health, the drug use, some other matters, and people generally, even if they don't know all the specifics, there's my form, thank you. even if they don't know all the specifics, people are kind of understanding now that there's kind of more than two sides to the story here, and maybe multiple sides, and people aren't, I don't think, generally as quick to say, yes, he's guilty. They will say, yes, he did it. I saw the video. I saw what happened. It's intolerable. It's heinous. It should have never happened. But then when they start thinking about, did this man commit murder, given all these other factors, there's a real declination of people to take that position. As I said, that shift from 55% to 29%. I mean, I don't want to overstate it. You know, we don't do criminal cases based on polls of people living in Alaska or Florida or Missouri. But nevertheless, I think it shows the public mood that the more they hear generally about some of these other factors, oh, he was using drugs. Oh, he had a bad heart. Oh, he had an encounter with police like this a week before. All those things are making people say, yeah, okay, I saw what I saw. And what I saw, I'm not going to say what happened was good or certainly acceptable, but maybe it wasn't a crime.
I would imagine there's going to be like a physical, component of it, of where was his knee on his neck, and was it his airway or was it some blood vessels, right? So maybe he had a little bit of air for a while, but once you cut off blood circulation, do you think that they're going to go into those different kind of medical?
Oh yeah, it's going to be real. Yeah, it's going to be real in-depth medical. Yeah, it's going to be like a tutorial on it's going to be like in medical school or something. It's going to be like being in an autopsy. Yeah.
Marshall, there's quite a bit of chatter about systemic racism, that somebody goes in and shoots 8 people in a grocery store and is escorted to jail, not killed. That was a white person. It seems like as often as not, a black person steps out of a car with a knife and gets shot 20 times. That happened in Minneapolis. So it's that I'm just kind of wondering what kind of social media is going on and trolling even to kind of push the mentality towards a black person dying who has a criminal record deserve to die.
Yeah, well, there's probably a lot of it. I don't know, Brian. You can go on the internet and find it. I suspect there's a fair amount of that. Now, again, that's the jurors aren't supposed to be seen, and I think that's pretty easy for the jurors to avoid that kind of stuff.
Right.
But part of it is, as you said, it's systemic. I mean, saying don't watch TV, don't go on the internet for the next month or so. I mean, these attitudes that people have, including all of us here, I guess. I mean, the attitudes that we formed about these issues are systemic. They go back a long time before the internet. So just saying, don't look on the internet and don't read any, don't go on Twitter don't read Twitter. It doesn't address the deep-seated ideological and feelings and attitudes that people bring into a courtroom.
You know the age range of the jurors?
Maybe so. They're mixed. It skews older, but all jurors skew older. It skews. It's higher than the general demographics, but there aren't a lot of older people, and certainly oftentimes you find retired people or older people in juries. This is mostly a 30 to 50 age jury group. It skews a little bit older than the general dynamics, but of course the jurors are drawn from voting rolls and voter rolls and driver's licenses, so you kind of eliminate a lot of younger people, and you eliminate a lot of older people too, for that matter, who may not have driver's licenses. It's a pretty typical jury in terms of age. And I don't remember what the gender breakdown is, but that's all typical. But what is unusual is I think there's 6 people who self-identify as people of color. And that's fine. And that's being critical about. I'm just saying it's an unusually high proportion for just about any jury, even in cities that have greater minority populations, Chicago and New York. And because for a lot of reasons, sociological and systemic and economic and reasons we could go into for a different occasion, the jury, the pool of jurors generally does not encompass a demographic breakdown compared to the society at large, for a lot of reasons. I was on a so-called blue ribbon panel about 12 years ago, dealing with grand juries, not juries, and there was just the paucity of people of color on grand juries in the Twin Cities was enormous. It's not that they didn't try, that the system wasn't trying, but they just weren't getting the people who, if you use voter rolls, change a little bit, use driver's license records and kind of the traditional ways, you tend to get more conventional white middle-aged people, and you miss not just race, you miss younger people too. You really miss young people on juries. It's extremely rare.
demographics, more people of color in the younger generations as well. So
Yeah, absolutely. Yeah, absolutely. But you know, the jury's a pretty good mix of different types, and it's about what we expected, except for the larger percentage of people of color, which I was a little bit surprised that they had that many. All right. Well, I hope this was interesting and informative. Lots of fun, lots of good questions, and thank you. And if you want to have me back again, maybe we'll talk about it in the summer.
know where to find you.
Okay. Thanks a lot.
Thanks.
We'll be in touch. Thank you, Marshall.
Thank you,
Bye-bye.
everybody.
And I'll send you my $2.
Thank you. I'll be
No,
taking
I won't send it. I'll drop it off. I don't send things to Peggy.